Just moments ago, a new court filing connected to Donald Trump quietly entered the legal system, and almost immediately it triggered what multiple legal insiders are now describing as an emergency-level review. This was not a routine submission, not a procedural update buried deep in paperwork. The filing appeared suddenly, and within minutes it began circulating among court watchers, attorneys, and analysts who understand when a document changes the temperature of a case. The reaction was fast, focused, and unusually serious. What set off alarm bells was not only the timing of the filing, but its implications. Legal experts say the motion raises questions that cannot be deferred or casually dismissed. Instead of fitting neatly into an existing schedule, it cuts across it. It forces the court to pause, reassess, and examine issues that go directly to authority, process, and jurisdiction. That is why the term emergency review is now being used quietly but consistently in legal circles. Many observers believe the case had entered a stable phase. Deadlines were known. Arguments were expected to follow a familiar sequence. This filing disrupts that sense of order. Attorneys reviewing the documents say it introduces legal challenges that, by their nature, demand immediate attention. Courts are obligated to ensure that proceedings rest on solid procedural ground, and when that ground is formally questioned, everything else slows down until clarity is restored. Inside legal circles, the response has been intense but controlled. Experienced attorneys are describing the filing as deliberate and highly calculated. There are no signs of haste or sloppiness. The language is precise, the arguments carefully framed, and the structure suggests the motion was prepared well in advance. That detail matters because it indicates strategy rather than reaction. This was not filed because something unexpected happened yesterday. It was filed because Trump's legal team believed the moment had arrived to force a review. Another factor amplifying the reaction is how the filing appears to anticipate resistance. Portions of the motion read as though they were written with the court's potential objections already in mind. Legal analysts say this is a hallmark of experienced litigation strategy. By addressing likely counterarguments before they are raised, the filing narrows the court's options and shapes the debate from the outset. That approach can turn even a denial into a strategic advantage, depending on how the court explains its reasoning. Opposing legal teams are now facing a difficult situation. Responding quickly risks elevating arguments they may want to contain. Responding slowly risks signaling uncertainty or conceding urgency. So far, public silence has dominated, and in high-profile cases, silence usually means internal reassessment is underway. Lawyers are recalculating timelines, reviewing prior assumptions, and preparing for procedural shifts they did not expect to confront this soon. What is also drawing attention is the absence of aggressive public messaging from Trump's side. There have been no immediate media appearances framing the filing, no rapid-fire statements attempting to control the narrative. Legal experts interpret this restraint as confidence. When teams believe their filing will compel serious consideration, they often allow the document itself to generate pressure. In this case, that pressure is already building without any public amplification. Court watchers are now focused on how the judge will respond procedurally. Will the court request expedited briefing? Will it call for clarification or supplemental filings? Will it temporarily pause other aspects of the case while the issues raised are examined? Each of these possibilities carries different consequences. Even a short procedural order could signal how seriously the court views the arguments. In cases like this, procedural signals matter as much as final rulings. Beyond the immediate case, this filing is being watched for its broader implications. Legal arguments raised in prominent cases often influence how similar issues are handled elsewhere. Attorneys across the country are paying close attention, not because they expect an instant ruling, but because they want insight into how courts are responding to challenges involving authority, scope, and procedural limits. That broader relevance is one reason the reaction has been so strong. As the legal world continues to digest the filing, one theme is becoming clear. This motion has changed expectations instead of a slow, predictable process. The case now feels unsettled again. Uncertainty has returned, and uncertainty drives attention. Supporters see opportunity in that disruption, critics see risk, the court sees responsibility. At this moment, no decision has been issued and no outcome is guaranteed. But the effect of the filing is already visible. It has triggered emergency-level review, forced recalculation, and shifted focus back to the foundation of the case itself. In major legal battles, moments like this often define the next phase. And right now, the legal world is watching closely, aware that whatever happens next will not be routine. As the emergency review process quietly takes shape, legal experts are beginning to explain why this moment matters. More than it may appear on the surface. Courts reserve heightened attention for filings that challenge the foundation of a case, rather than its surface details. According to attorneys familiar with similar situations, this motion appears to do exactly that. It does not simply argue about evidence or scheduling. It questions whether the process itself is proceeding on solid legal ground. When that happens, judges are required to slow everything down and take a closer look. What's driving concern inside legal circles is how this filing compresses decision-making. Normally, courts have the luxury of time. Arguments unfold over weeks, sometimes months. Emergency review changes that rhythm. It forces prioritization. Other matters are pushed aside, while the court determines whether immediate action is necessary to preserve fairness and authority. Even if the court ultimately decides no emergency action is required, the act of reviewing the claim reshapes priorities and focus. Several former prosecutors and defense attorneys say, the filing appears designed to trigger exactly this kind of procedural pause. By formally raising issues that touch jurisdiction, authority, or procedural legitimacy, Trump's legal team has put the court in a position where ignoring the filing is not an option. The judge must address it, and how the judge addresses it will be read as a signal by everyone involved. That is why this moment feels heavier than a standard legal maneuver. Behind closed doors, opposing legal teams are now reassessing their assumptions. Strategies built around predictable timelines may no longer apply. Arguments prepared for later stages may need to be accelerated or revised. Even the tone of future filings may change, depending on how the court frames its initial response. Legal battles at this level often turn on subtle shifts, and this filing has introduced several at once. Another layer of tension comes from how emergency reviews can expand the scope of judicial inquiry. When a court examines whether a process is proceeding correctly, it often revisits earlier decisions, rulings, or assumptions. That does not mean those decisions will be reversed, but it does mean they will be scrutinized. For legal teams on both sides, scrutiny introduces risk. Past choices that once seemed settled can suddenly come back into question. Court observers are also noting how carefully the filing is written. The arguments are framed in a way that invites engagement rather than confrontation. Instead of accusing the court of wrongdoing, the motion emphasizes clarity, fairness, and procedural integrity. Legal analysts say this approach is intentional. Judges are more receptive to arguments that align with their own responsibilities. By framing the motion around the court's duty rather than the court's failure, the filing increases its chances of serious consideration. Public reaction, meanwhile, is beginning to catch up with the legal reality. Media coverage is shifting from initial headlines to deeper analysis. Commentators are no longer asking whether the filing matters, but how much it matters. That transition is significant. It signals that the story has moved from novelty to consequence. Once that happens, attention tends to build rather than fade. Trump's legal team remains notably quiet as this unfolds. There has been no attempt to oversell the filing or predict outcomes. Legal experts say this restraint is consistent with a strategy focused on the court rather than the public. By avoiding inflammatory statements, the team allows the seriousness of the motion to stand on its own. That seriousness is now being reflected in the tone of coverage and commentary. Inside the courthouse environment, anticipation is growing. Clerks, analysts, and attorneys are watching the docket closely for any procedural update. Even a brief order acknowledging the motion would be meaningful. The timing of such an order could indicate urgency. The language could indicate concern or caution. In high-profile cases, these details are dissected relentlessly because they often foreshadow larger decisions. What makes this phase particularly unpredictable is that emergency reviews do not follow a single script. Courts have wide discretion in how they handle them. Some choose narrow responses, addressing only the most immediate issue. Others take a broader view, using the moment to clarify procedural boundaries. Which path this court chooses will reveal a great deal about how it views the case as a whole. Legal scholars are also pointing out that this filing could influence parallel proceedings. Even if the emergency review is limited in scope, the court's reasoning could be cited elsewhere. Attorneys in other cases are already paying attention, looking for language they can use or avoid. That ripple effect is one reason high-profile filings carry weight beyond their immediate context. As uncertainty continues, the psychological impact is becoming apparent. When cases feel predictable, parties grow comfortable. When unpredictability returns, caution increases, decisions slow, risks are reassessed. Trump's filing has reintroduced that unpredictability at a critical moment. Whether by design or by consequence, it has forced everyone involved to pause and reconsider. At this stage, the emergency review has not produced a ruling, but it has already reshaped the environment. The case is no longer moving quietly forward. It is under examination, not just for what it argues, but for how it is being handled. That shift matters in complex legal battles. Moments when the process itself becomes a focus often precede significant turning points. As attention remains fixed on the court, one reality is becoming harder to ignore. This filing was not meant to blend in. It was meant to interrupt, to compel, and to force engagement at the highest level. And while the outcome remains uncertain, the impact is already visible. The legal world is no longer watching passively. It is waiting, aware that the next procedural move could redefine what happens next. As the emergency legal review unfolds, the atmosphere around the case is becoming heavier by the hour. Courts do not initiate heightened scrutiny lightly, especially in matters already under national attention. Legal experts emphasize that when judges pause to reassess the process itself, they are signaling concern about foundational questions, not surface-level disagreements. That concern does not automatically favor one side, but it does elevate the stakes for everyone involved. Once a case reaches this phase, every subsequent move carries added weight. What makes this moment especially consequential is a range of possible outcomes now on the table. The court could issue a narrowly tailored response, addressing only the immediate procedural issue raised. But it could also take a broader approach, clarifying rules, timelines, or authority in ways that reshape how the case proceeds. Even a carefully worded order could redefine expectations moving forward. Legal scholars note that some of the most influential moments in high-profile cases come not from final verdicts, but from interim decisions that quietly redirect the path. Trump's legal team appears prepared for that reality. Observers familiar with complex litigation say filings like this are rarely gambles. They are calculated moves designed to generate value regardless of outcome. A favorable ruling creates momentum. A partial ruling creates clarity. Even an unfavorable ruling can establish a record for appeal or expose limits that can be challenged later. In that sense, the emergency review itself becomes a strategic asset. Opposing counsel now faces mounting pressure as the court's attention sharpens. Every response must be precise. Overreach risks alienating the bench. Underreaction risks conceding ground. Legal analysts say this balancing act is where cases are often won or lost. The margin for error narrows as scrutiny increases. Arguments that once seemed sufficient may no longer be enough when examined under emergency conditions. The political implications are also intensifying. Legal developments at this level rarely stay confined to courtrooms. They spill into public discourse, influence messaging, and shape perception. Supporters interpret the emergency review as evidence that the system is being challenged in ways it cannot ignore. Critics frame it as an attempt to disrupt accountability. Both narratives are gaining traction, and both are feeding engagement. That engagement ensures the issue remains active, debated, and amplified. Inside Washington, strategists are watching closely. Emergency legal reviews create uncertainty, and uncertainty complicates planning. Messaging calendars are adjusted, assumptions are revisited. Parallel strategies are put on hold until clarity emerges. This ripple effect is part of why emergency reviews carry such influence. They slow momentum, force reassessment, and keep outcomes fluid. The court itself now occupies the center of attention. Judges are aware that whatever response they issue will be examined line by line. Language will be parsed for meaning. Timing will be interpreted for urgency. Even what the court chooses not to address will be noted. In high-profile cases, judicial restraint can speak as loudly as judicial action. That awareness adds pressure, but it also underscores the seriousness of the moment. As days pass without a definitive ruling, anticipation will continue to build. Media coverage will intensify. Legal commentary will grow sharper. Every docket update will be treated as a potential signal. This is a phase where uncertainty dominates, and uncertainty often favors those prepared to operate within it. Trump's legal team has shown repeatedly that it is comfortable allowing ambiguity to work in its favor. Legal scholars are also pointing out that the emergency review could influence how similar cases are handled in the future. Courts learn from each other. Language used here may resurface elsewhere. Arguments tested here may be refined or avoided in other courtrooms. That broader impact is one reason attorneys nationwide are paying attention. This moment is not isolated. It is part of a larger legal conversation. What cannot be ignored is that this filing has already achieved something significant. It has forced the legal system to pause and examine itself. It has disrupted assumptions about pace and predictability. It has shifted focus from outcomes to process in complex legal battles. Those shifts often precede meaningful change. Whether the court ultimately grants relief, limits the scope, or denies the motion entirely, the consequences will extend beyond a single ruling. The reasoning will matter. The tone will matter. The timing will matter. Each element will shape how the case moves forward and how future challenges are framed. For now, the legal world waits. The emergency review continues quietly, deliberately, and under intense scrutiny. The next order, no matter how brief, will carry significance far beyond its length. Until then, uncertainty reigns, attention remains fixed, and the system itself is on display. One thing is already clear: this unexpected court filing has changed the dynamics of the case, and whatever comes next will unfold under a level of scrutiny that few legal battles ever reach.